Count 1, malice murder. We, the jury, find the defendant, Travis McMichael, guilty. I'm going to ask that whoever just made an outburst be removed from the court, please. Count 2, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 3, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 4, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 5, felony murder. We, the jury, find the defendant, Travis McMichael, guilty. Count 1, malice murder. We, the jury, find the defendant, Greg McMichael, not guilty. Count 2, felony murder. We, the jury, find the defendant, Greg McMichael, guilty. Count 3, felony murder. We, the jury, find the defendant, Greg McMichael, guilty. Count 4, felony murder. We, the jury, find the defendant, Greg McMichael, guilty. Count 5, felony murder. We, the jury, find the defendant, Greg McMichael, guilty. Count 1, malice murder. We, the jury, find the defendant, William R. Bryan, not guilty. Count 2, felony murder. We, the jury, find the defendant, William R. Bryan, not guilty. Count 3, felony murder. We, the jury, find the defendant, William R. Bryan, guilty. Count 4, felony murder. We, the jury, find the defendant, William R. Bryan, guilty. Count 5, felony murder. We, the jury, find the defendant, William R. Bryan, guilty.
Deliberations are over. The jury is in fact in, and Travis McMichael, Greg McMichael, and William R. Bryan are all found guilty in their role in the death of one Ahmaud Arbery. Now, for some reason, even though we've broken down why this was the most likely outcome on this channel ever since video 1 that I did on this topic, there's a lot of confusion as to the verdict, as to the charges in relation to this case, and I'm going to clear all of that up for you to understand why this was the most likely outcome, even before the judge completely nuked the defense's argument, as stated in my previous video. But first, we got to talk about your health, we got to talk about your hair, your nails, and your skin with Health with Justice. We are only just now starting to understand the powerful anti-aging effects of taking collagen. I myself and thousands of others have personally experienced these effects firsthand. But there's a little bit of a secret, something that you might not realize. I don't just go to the store and buy myself some crappy collagen off the shelf. I go to Health with Justice. This special collagen provides 5 key collagen types from 4 unique sources. In short, this blend supercharges the effects that typical collagen would have. The result? Firstly, my skin looks and feels as soft as itty bitty baby Sean's skin felt. Second, my nails are so elite that my girlfriend is a bit jealous. And thirdly, and this was the most unexpected, I have more energy to go about my day. Just look at the level of enthusiasm I have in this video you're watching right now. But guess what? The benefits are not just for me, they are in fact for thee. Go to healthwithjustice.com, and for you, this month, you will get our very special Black Friday 51% off your order of this very special collagen powder. Trust me, if you get it, your skin, your hairs, and your nails will thank me. That's healthwithjustice.com, link in the pinned comment and in the bio. So as we all should know, on February 23rd of, I believe, 2020, the McMichaels and Bryan chased down suspect in burglaries in their neighborhood, Ahmaud Arbery, onto a street. There's video out there. I'm not going to show it. It's very graphic, but you can see in the short little bit of video released by William Bryan, who, by the way, basically secured all of the guilty convictions by releasing that video, even though he believed that it would prove them innocent, that during the course of Arbery trying to run away, he made a move and then went around the truck and attacked Travis McMichael, grabbing the shotgun, where he was shot a couple of times. Arbery ended up dying, and originally this was ruled an instance of self-defense. And based on the parameters that we see in the video, without any overall context, it does look like a self-defense case, or it looks like a murder, depending on how you look at it. But it all came down to whether or not the McMichaels were legally within their rights to stop Ahmaud Arbery in the way that they did, using deadly force. Now, there was a lot of confusion surrounding Georgia's citizens arrest law, which is honestly just 2 sentences, and I understand because there was terrible reporting, because activist attorneys like Benjamin Crump came to the state of Georgia and they gave a bad interpretation of the law that was put out in the media. And essentially, the argument that was originally put forward is that you can only stop people or initiate citizens arrests based on if the person is suspected of or there's probable cause that this person committed a felony. Turns out that is not the case. The judge clarified this very specifically in his jury instructions. We covered it in the last video, but I want you to understand what the judge was arguing before we move forward.
I don't read the statute the same way as the defense. I read into the statute. The first line addresses both felonies and misdemeanors. The second sentence narrows that then down to felonies. It doesn't discount misdemeanors. It just says in the case of felonies, if there's an escape going on, then the arrest can be effectuated. The way I read that is if it's a misdemeanor, the guy can be arrested, gal, whoever it is, can be arrested by whoever is effectuating the citizen's arrest. But if they run, then you can't go chasing after misdemeanors. In the case of a felony, you can. And a person who is chasing somebody who's escaping on a felony that is justified upon reasonable and probable grounds for suspicion can effectuate the arrest.
So to be clear, you can initiate a citizen's arrest if you see or have immediate knowledge thereof of somebody committing a misdemeanor. This should be shocking to nobody because in the state of Georgia, the most common use of citizen's arrest doctrine is in shoplifting cases, which tend to be misdemeanors. So again, people who reported that, who just went with what Benjamin Crump says, who doesn't practice in the state of Georgia, are just reporting off of ignorance, going off of headlines, and not looking into the facts of the case. On top of that, it's actually not in dispute by the prosecution, by the police force, or by the McMichaels that they suspected Arbery of committing felonies. There were a series of burglaries in the area. Only one was reported to the police, and that was a burglary of Travis McMichael's gun. But there were calls into the police as it came out in trial, and the police had actually come out to search for Ahmaud Arbery specifically in that area before he knew his name. We saw video of Arbery in the house multiple different times. Contrary to counter reports in the media about nothing ever being stolen from the property, nothing was stolen from the construction site portion of the property, but there was stuff stolen from areas not covered by surveillance video, and the thefts coincide with Ahmaud Arbery's appearance there. On top of that, we found out in a pretrial motion from the McMichaels defense team that Ahmaud Arbery had a history of stealing and breaking into places, and wouldn't you know it, the cover that he used in order to get away with this was pretending like he was exercising or jogging. In fact, in some of the instances, he was referred to as a jogger, and this was years before the fabled incident that led to his death. So this is very interesting information that would lead us to believe that Ahmaud Arbery was a burglar. He was not jogging. He used jogging as a cover for his crimes. However, this was not determinative of whether or not the stop of Arbery was justified. You see, the McMichaels defense team conceded in a court of law the first sentence of Georgia citizens arrest law. This had to do specifically with the seeing or having immediate knowledge thereof of a felony or misdemeanor. Here's the video so you can understand what they were arguing in the court.
We're not contending there was a crime committed in their presence, but there was probable cause to believe a felony had been committed and that this man was attempting to escape or flee.
Now, the reason this is crucial to this case is this defense I thought was actually really clever, and there was a part of me that thought, based on the way that the statute was written, the McMichaels could actually get off, even though my initial impression was that this was a felony murder. And if you guys don't remember the exact wording of the statute, we're going to go over it right now. A private person may arrest an offender if the offense is committed in his presence or within his immediate knowledge, period. And that period was very crucial to the defense's case. If the offense is a felony and the offender is escaping or attempting to escape, a private person may arrest him upon reasonable and probable grounds of suspicion. So it's these two sentences, a law that dates back all the way to 1863, that determine whether or not the McMichaels were acting lawfully or unlawfully in this instance. And by the way, the judge agreed with part of the assessment of the defense team. Contrary to what was reported in the media, you can stop somebody for citizen's arrest, according to the judge and everybody involved in this case, for misdemeanor or felony, any offense, as long as you see it or have immediate knowledge thereof of the offense. Where things come into dispute is this whole thing about if there's a felony, and the defense was arguing that there's a separate standard laid out in the felony portion of this that basically says reasonable suspicion is enough to initiate a citizen's arrest against a felony person. Now, Ahmaud Arbery had more than reasonable suspicion against him that he was committing a felony, or that he was a fleeing felony, or that he previously committed a felony. Again, he was the burglary suspect that everybody in this neighborhood was looking for, that showed up on multiple surveillance videos at multiple locations. He was in fact the guy. That is not in dispute. However, the judge saw it differently. The judge basically ruled in his jury instructions that after the original offense, the original fleeing, the ability to make a citizen's arrest is neutralized, or in his words, the ability to do so is in fact extinguished.
So, the charge that I am going to provide, I'm going to amend a little bit from the state's language, and that is that a private citizen's warrantless arrest must occur immediately after the perpetration of the offense, or in the case of a felony, during the escape. If the observer fails to make an arrest immediately after the commission of the offense or during escape in the case of a felony, his power to do so is extinguished.
Now, based on these instructions as laid out by the judge and handed to the jury, as we covered in our previous video, a guilty verdict was almost guaranteed, because the judge, ignoring that secondary standard for felonies in his jury instructions, and remember, the jury has to rely solely on the judge's interpretation of the law as laid out by the jury instructions, it was a guaranteed conviction for the McMichaels on at least the felony murder counts. And to be fair to the defense, even though my initial reading of this statute was that we were going to end up with felony murder convictions, which is what we ultimately ended up with, there are two different standards in each sentence, and it would seem reasonable that the writers of this law outline those two different standards for a purpose. So based on this law, I could see in an appellate court the convictions of the McMichaels and of Bryant being overturned, because if the law is vague or the law is confusing, it's supposed to be given to the defendant. In this case, it was not. It was given to the state. Basic jurisprudence in the United States of America is if the state messes up in terms of vagaries, that's on the state. They need to change it, since they're the ones who are trying to deprive citizens of their freedom. However, assuming that the judge's instructions hold, assuming that he was correct in his assessment, this is a textbook case of felony murder. The McMichaels chased down, they tried to trap Ahmaud Arbery twice at least, and on the second time, for no real reason, Travis McMichael got out of his vehicle with a shotgun at the ready, and he was pointing it, or prepared to point it, in the direction of Arbery. We all know Arbery went for the gun. Nobody reasonable should dispute that once Arbery goes to the gun, as long as the McMichaels are legally in the right up until that point, this is a textbook case of self-defense. But if they're legally into the wrong, then they basically created a scenario where somebody with a violent history like Ahmaud Arbery, somebody who fights back against people who accuse him of crimes that he did commit, whether they be police or everyday citizens, might act out in an aggressive way, thus resulting in the death of him, thus making the McMichaels ultimately responsible for that death. Now, as far as the charges go that he was actually convicted on, or that these people were convicted on, I can agree in principle in terms of legality with virtually every charge except for the malice murder on Travis Michael. Now, in the state of Georgia, they technically don't require intent for their malice murder. However, they require something that's vaguely similar, that at least is, like a lack of care or ability to inflict harm. It's like aforethought. Usually we have malice and aforethought with premeditation. And I don't think the McMichaels fit that. Now, it doesn't matter, because felony murder is the death of somebody while you're during the commission of a felony. And contrary to popular belief, this is not a reduced sentence crime. You can get the death penalty in the state of Georgia, as in every other state, you can get the maximum penalty for felony murder. That's the purpose of felony murder statutes. So this is the reason why not just Travis McMichael, but Greg McMichael and William Bryan are all convicted of felony murder, because it was proven that each of them participated in one of the many additional felonies that resulted in the death of Ahmaud Arbery. This is one of the reasons why Bryan, who was back filming this, ended up being tagged with felony murder, and he is facing life in prison. And for those of you who are confused why there's so many counts of felony murder that they were found guilty on, the way this works is that each of the felony murder charges are attached to a specific felony. So all they're really finding them guilty on is the underlying felony. They're not going to get 5 consecutive life sentences for the 4 felony murders and the 1 malice murder. It's 1 murder, 1 sentence, but as a formality, when they find them guilty of the underlying charge and somebody died, that is a count of felony murder. So that's what's going on here. So while legally, the only charge that I can disagree with and make a strong legal case against in terms of the verdict is in fact the malice murder charge. I thought this was felony murder straight up, and a lot of different attorneys agreed with me. There's really nothing else in terms of legal analysis. If you find them guilty of the underlying crimes because Ahmaud Arbery is in fact dead, it is by definition felony murder. It's automatic. You almost don't have to even have a verdict on the felony murder charges because it's about somebody dying during the participation of a felony. Now, with that being said, there is a moral component of it that I feel very questionable about, and this is something that often comes up whenever we cover felony murder charges. Now, normally, felony murder, great example for you guys to understand, is a bunch of people go and they participate in a bank robbery. One person in that party shoots the bank teller and kills them, and all of the people get charged with felony murder because they all agreed in a consensual way, in a premeditated way, to participate in that bank robbery, so that serves as the intent required for the murder. The murder was a likely consequence of their actions, therefore, that's why they all go down, and that's why that law exists, and that's why I understand that law, and in a lot of cases, I support that law. However, the case of William R. Bryant is a little bit more questionable because while it is true in the first instance he did participate in trying to trap Arbery and he was participating in the chase of Arbery, he clearly hanged back at this point. And in my mind, at least legally, I think the law should reflect the idea that this is a separate instance. Much like in the Rittenhouse case, you have 2 separate instances of shooting. I feel like this should be the case in this instance because in reality, at this point, he is not participating in waving guns or threatening Arbery or anything like that. He's attempting to document what's happening. He's hanging back and doing what we all wanted the McMichaels to do in the first place, which was hang back, keep an eye on Arbery, and wait for the police to show up. So at this point, even though legally the conviction of felony murder is in fact sound in the state of Georgia against William R. Bryant, morally, I think that he did not participate up to the point that these guys participated in. Thus, it doesn't make sense to tag him with the felony murder, in my mind, in my personal opinion. Now, to be clear, this isn't the most egregious application of felony murder that's ever happened in this country. It's probably not the most egregious application of felony murder that ever happened in the state of Georgia, but my job is not only to just break down the laws, give you the facts of the cases, give you the background that may or may not be included in the court of law, but it's also to give you my opinion and my analysis and to point out where I think there are in fact flaws in statutes across this country. And I think that there's a major flaw in felony murder because if you just participate in any felony that's covered under the statute, no matter your level of participation, you can be tagged for what will be a life sentence level crime. And to me, that just doesn't make a lot of sense. At this point in time, he did exactly what we would have wanted these people to do in the first place, which was document, follow, don't engage, don't confront, don't get in front, and he's going to be tagged for that. And they say that he helped box Arbery in. If you look at the video, Arbery had plenty of room to run to the right. He had plenty of room to even try to run to the left. However, he was trying to dodge the McMichaels. And this guy was well far back in this scenario, not really putting the pressure on Arbery in this moment. So, while I do agree that he should have got some of these other charges based on Georgia law, if these were first offense charges, if Arbery didn't die, these people would have got probation maximum, although Arbery probably would have resisted arrest from the police, which is something that he's done in the past, and would have been arrested on suspicion of burglary had nobody died. But in reality, the McMichaels made major errors. Travis McMichael should have never gotten out of the car. It is 100% on them in terms of Georgia law, especially with the way that the judge read the statute to the jury, with the way that he gave them the jury instructions. Now, to be clear, this case was not totally contingent on the judge essentially nuking the defense in the jury instructions. There was a good chance that had this not happened, and had he gave them a more reasonable or a more fair-minded interpretation that allowed them to consider the defense's argument, the jury would have came back with the same verdict. That's how not good this case was. That's how not good this video looked. That's how not good all the circumstances surrounding this were. But we have to be honest. We have to be honest about everything. We have to be honest about Arbery not being this angel that was just jogging. We know for a fact that he was burglarizing the area, but it's important to understand that just because somebody is accused of a burglary or is the burglary suspect from a previous burglary, that doesn't necessarily mean that you can chase them down in the future. So I do understand the verdict. This is the verdict that I've been predicting from the jump, but I want to know what you guys think down in the comments below. If you like the video, show me by leaving a like, subscribe for more content, follow me on all my social media, support me via the support links. This has been me talking about the Arbery case. Till next time.